Yes. Now, Mr. Chapman.
I mean, I hope to be relatively brief, and I'm grateful for the early rise for lunch. I have
Good.
cut down my submissions.
Good.
Before I turn to the specific grounds, can I make essentially the headline point, which is that I respectfully agree with the proposition that at its heart, this appeal is about the meaning of the directive.
Yeah.
And that's why we said in our skeleton, ground 3 adds nothing to ground 2. Either the directive inheres a civil law remedy or it doesn't.
Yeah.
We say what would be required is a sufficiently clear, precise and unconditional provision creating an individual right, giving rise to civil...
Hold on.
Ah, sorry, I'm being too quick.
Yes, you are. Clear. What was the second adjective? I got clear.
What would be required is sufficiently clear,
Yes.
precise,
Yes.
and unconditional provision creating an individual right from which a right to civil law damages for breach inheres.
What was the verb? Inheres.
Inheres.
What's your authority for putting it in that way?
Well, I can take you to them in due course, but that's better.
Okay. Yep.
It would have to be sufficiently clear, precise, and unconditional in relation to, amongst other things, the content of that right. Again, Becca.
When you say content, do you mean what equipment or who has the right or both?
I mean what specifically the right is. And my Lord Justice Baker asked Mr. Carter to say what he says that right is, the question that the court must ask. We suggest that it is striking that Mr. Carter was unable to propose consistently the content, the specific content, the nature of the right that he says is sufficiently clear, precise, and unconditional within the directive.
Why isn't it the right to receive suitable equipment?
Can I move on? Can I come back to that, please? There are I suggest that when one turns to the directive, and I propose we do that now, it is there is an insufficient right to give rise to private law damages. So let's turn to the directives, starting with the Work Equipment Directive at page 18 of the authorities bundle.
Mm-hmm.
Mr. Carter relies, in terms of the recitals, squarely on recital 6.
My Lord Justice Lewis it suggested that Article 6 should be read in the context of Article 3.
Yes. Well, I'll turn. If I may, I'll turn to both of them. So, first, Article 6 requires compliance with minimum requirements, designed to guarantee a better standard of health and safety, and that compliance is essential to ensure health and safety. Breaking it down.
Of workers.
Of workers. Yes.
That's not unimportant.
It may not be.
Well, yeah.
Recital 3 refers to the adoption of minimum requirements for encouraging improvements so as to protect health and safety of workers.
Yeah.
So those are the recitals. I suggest, and I'll develop this in due course, there's nothing in there that inheres a right.
No, but it tells you what the purpose of this
It
is.
does.
Is to look after the safety and health of workers.
It does.
So they're a possible likely candidate.
I,
I have rights.
I accept that. Turning to
And should I just,
Yes.
you'll forgive me, point out that there are maybe other things in these recitals which stress that it's the safety of workers that's at the forefront. For example, I'm not concerned with it, but recital 8. Anyway, you want to take us to the articles, do you?
yes, please. Or I'll turn over the page to chapter 2, which has the heading Employers' Obligations.
Well, so sorry to be grim. It's always better to start at Article 1, begin at the beginning. This directive lays down minimum safety and health requirements for the use of work equipment by workers at work. That's what it's all about, is
Yes.
laying down minimum requirements.
Yes. Yes, and of course, member states may choose to enact more substantive requirements. But I accept that the premise of this directive, and I'll turn the court to the framework directive in due course, is about enhancing protection, reducing the likelihood of injury in the workplace. So, turning to chapter 2, employers' obligations, I note for what it's worth that this is all cast in terms of obligations on the employer and not employees' rights. Indeed, nowhere does it refer in turn to the creation of employees' rights. Article 3.1, as the court has observed, requires...
There is one, I mean, actually looking it over, there is one area which is, I think, probably construed as conferring rights on workers, which is Article 10, which is the right to be consulted and participate
Yes.
in.
Yes, I readily concede that. Insofar as relevant here, this is, I don't labour the point, but it could have been cast in terms of rights, and it's not. Article 3.1 requires, as a general obligation, employers to take the measures necessary to ensure, etc., that the work equipment is, in inverted commas, suitable for the work.
And there's a second obligation, and may be used by workers without impairment to their health or safety.
Yes. Yes.
And you missed out the phrase made available to workers.
Made available to workers. If there's, I'll be clear. I take absolutely no point that this is not directed towards ensuring health and safety of workers in the workplace.
So why do you say that doesn't give them rights?
I don't say it doesn't give them rights, and I'll turn on to what this does create. But what I will focus on in due course is what precisely the content of that right is and what that means.
And we didn't look at the second half of 1, but that's all in the same vein, isn't it?
It's all in the same vein, yeah.
And as is 2.
Well, two is the caveat to 1.
Yes.
So whereas 1 talks in terms of absolutes, ensuring that the work equipment is suitable, Article 3.2 caveats that and says, well, we don't really mean ensure. What we really mean is ensure so far as reasonably possible. I'm paraphrasing, because what 2 says is where it's not possible in this way to fully to ensure that the work equipment can be used by workers without risk to their safety or health, then the employer shall take appropriate measures to minimise the risk, or minimise the risks.
Is there any relevance in the word fully? Does it cast a gloss on the extent of the duty in 3.1?
Yes. So, what I'd suggest is that Article 3.1 and 2 need to be read together. And what one is saying on a black letter interpretation is that you have to fully insure all of these things. That, of course, is impossible.
Well, it's not impossible. Well, you say it's impossible to fully ensure the safety of.
It's impossible to fully ensure the safety of suitability of equipment by way of example, or that the specific working conditions, etc.
Sorry, I may be misunderstanding, but isn't the scheme of the of Article 3 is that the basic rule is it is the duty to ensure full protection, save that there will be circumstances where it's not. Isn't that the scheme? That's what it says, doesn't it?
When it says
Shall take the measures necessary to ensure. I'm emphasising so.
Yes.
To ensure is suitable and may be used without impairment.
yes. So requirement to take the measures to ensure one can read across from to the word fully. So this is saying take the measures insofar as you can, fully to ensure that the equipment is suitable, that the hazards are eliminated. 2 says, effectively, we recognise that it might not be possible fully to ensure those things by taking the measures. Therefore, in those cases where it's not, do your very best. In other words, what it says is, shall take appropriate measures to minimise the risks. So you might not be able to eliminate them, but if you can't eliminate them, do what you can to minimise them.
Would a fair reflection of 3.1 and 3.2 together be it's a duty of result subject to impossibility?
Basic rule for council: be careful when you accept properties reworded by a judge.
It's a duty. It's a duty to take the measures necessary to ensure that result.
Protection, yeah. To ensure use without impairment to safety,
Yes.
which is the result. Subject to, if it's not possible, you act appropriately.
Yes.
I mean, the whole thing could be worded: all employers shall take such steps as are reasonable in the circumstances.
Yes.
It doesn't say that. It says
doesn't say
your
that.
duty is an absolute duty in the first instance, save where it's not possible fully, in which case you must do what you can.
Yes.
Okay. Yes.
On that basis, the appellant asserts that he has, on the basis of this text, he asserts that he has a directly affected right. And in the end, in terms of the nature and content of that right, he arrived at a right cast in terms as a right as a worker to work equipment which is suitable. I suggest, accepting the premise that a corollary of an obligation is right, I suggest that there is no warrant for finding that the terms of this directive create the specific right for which the applicant contends. It is, I suggest, inconsistent with the terms of the directive itself because of the existence of that caveat.
What? 3.2.
3.2. So there is no right to be provided with suitable work equipment. There is a right to be provided with suitable work equipment if that's possible.
Well,
and the right, forgive me.
No, you complete it. Forgive me. You must complete your submission. Then I come back to you.
It is a right to be provided with suitable work equipment where possible, and where that is not possible, it is a right to expect the employer to take appropriate measures to minimise the risks.
I mean, it may be this is a distinction without a difference, but I'm not convinced that it is. how it's worded is, in terms of, if we look at if it is worded in terms of rights, it's an absolute right under 1, save where it's not possible. It's not a right. The obligation is not so far as reasonably possible. It's an absolute right, save where not possible. Now, as I say, that may be a distinction without a difference, but it is a distinction.
It is a distinction.
You say without a difference.
I say without a difference. Still less, when we're looking at the rights, still less do we say it is a right not to be injured through the provision of unsuitable equipment. It is a right which is cast in terms of, or insofar as it is a right, insofar as the obligations have as their corollary a right. It is a right to be provided with suitable equipment, except where impossible. And
so you said a couple of minutes ago, you accept there is a right, but not in the terms put forward by Mr. Carter.
yes.
So how would you define the right?
Well, can I move on to that in due course?
Yes.
I'm sorry, I'm rather.
No. I thought you were just there, but you're not. Carry on.
Well, what we would suggest is that it is, insofar as there's a right, it is a right to a domestic framework by which the employer's obligations are effectively enforced. And we suggest, and I'll develop this in due course, that is in line with conventional principles of national procedural autonomy, subject only to effectiveness, about which there appears to be no debate, and equivalence. So the choice of procedural mechanism by which the UK gives effect to the directive is for the UK subject to those principles. The appellant accepts that the mechanism that the UK has adopted through the rubric of regulatory and criminal law, supplemented by the availability of domestic law, tortious negligence actions, amounts to effective implementation. And I'll return to equivalence and develop my points on equivalence more deeply in due course. There is some CJEU authority on procedural mechanisms, and that's the MG case that we transmitted to the court yesterday. And could I ask you to turn to that now?
Before you take that, if you look, when you look at one article, if you look at Article 5, for example, inspection of work equipment, that says the employer shall ensure that there is initial inspection and so on. And 2 says in order to ensure that there have to be periodic inspections. And then 5.4 says member states to determine the conditions under which such inspections are made. Now there you can see that the nature of the right isn't specifically linked with the worker being able to do anything. Periodic, annual, member states having a discretion to their conditions, all of that might suggest that that provision, inspections, isn't something that is conferring specific entitlements on individuals. Article 4.3 talks about member states dealing with procedures for the things in Annex 2. But when you get to Article 3, if you work backwards, the nature is very different. There's nothing that gives any kind of procedural autonomy to member states. And there's very specific direction. You need to be provided, as far as possible, with safe equipment. So that looks more like a specific obligation with a specific content, a right to safe equipment. And if you don't meet that, it can be dealt with in different ways. He can get an injunction, he can get damages if he's hurt. That's the argument against you. When you look at it as a whole, that specific provision has crossed the line into specific affirmative rights with any remedies necessary to enforce it.
Yes, well, this is for one of the my lord understands. I hope my argument that we don't accept that this creates.
I know, but when you look at 4 and in particular 5, doesn't that help us to think, oh, well, maybe 3 is different? You've got to look at the directive as a whole.
My suggestion is no, it doesn't.
That's fair enough.
I mean,
It's all right. It was interesting, but no cigar. That's fine. So.
Just to stop you from ever getting to an authority you want to get to, which is our practice, obviously. But Article 4 doesn't start by saying to implement Article 3, the employer shall obtain and or use. It says without prejudice to Article 3. So
Yes.
this is supplementary and over and above the general obligation in Article 3,
yes.
which suggests that there may be different answers to the question of direct effect, depending on which provision you're looking at, which is nothing unusual about that.
There might. Article 3 is, of course, cast in terms of general obligations. And so, in answer to my Lord, Lord Justice Lewis's question, it is, I'd suggest, not surprising that when considering the general observations, which is obligations, cast in relatively general terms, that there isn't a like provision concerning the precise mechanism, making clear, as for instance in Article 5.4, that it's for member states to determine the conditions for inspections. But the general position is that it is for, I'll move on to this in due course, that it is for member states to determine the precise mechanism by which a directive is given teeth, unless, well, in all circumstances, but I'll move on to it in due course, unless, and this is the nub of the question, Article 3 does clearly create provision, unconditionally, precisely, for which inheres rights to bring a civil damages claim.
A right to results rather than a right to a process or
Yes.
structure. Yeah.
So did you want us to look at MG?
Yes, please. And that's at the end of bundle 3.
Right.
Starting at page 984.
I've got it electronically. I think the Lords have both got theirs printed off.
So this is a 2020. It's a 2024 judgment, and may I apologise that we didn't find it until the weekend. It's in the 2025 law reports. Turning to start with to Advocate General's Advocate General Rantos's opinion at page 99.
Does this say anything about Article 3 in play at all in this?
Yes.
It is.
Well, certainly the Work Equipment Directive, as a generality,
Yes, but I was only about Article 3 particularly.
doesn't refer to Article 3 itself.
Okay, it's Article 1 and Article 5, isn't it? Right, okay. So, what do you want us to read?
I'll turn you the sidebarred paragraph starts at AG 36.
This is the Advocate General.
Yeah, Advocate General.
Yeah.
AG 39 is particularly relevant in that this authority is principally concerned with the Framework Directive I'll turn you to the Framework Directive in due course. At AG 39, the Advocate General talks about 2009/104/EC. And that's the Work Equipment Directive. And one sees final sentence of AG 39. Those directives also do not contain any specific provisions concerning the imposition of penalties on employers which have not ensured the protection of the safety and health of workers. And then turning forward to AG 46.
Could I trouble you, going, before we get to 46, look at 43,
Yep.
where there is a reference to individual rights.
Yes.
Protection of rights which individuals derive from EU law.
Yes. So the Advocate General here making the point that national procedural autonomy entitles member states to choose the mechanism by which rights deriving from a directive are given effect.
I know I'm a track record, but it's so unwise to start at AG 39, isn't it? Isn't it better to look at AG 36, the very first paragraph? And if you look at 36, that's talking about the provisions of the directive, 89.391, and it describes those as being general principles and so on. And in the light of that, it seems that they don't think it's specific rights on employees. And you get to AG 39, and the first half of that paragraph is all about that. And then you do have that mysterious sentence that you rely on at the end, which does cross-refer to 2009/104. But Article 3 may be very different from all of that in any event. But we need to have a full picture, don't we?
Well, my lord, if necessary, I would invite you to read either now or in your own time the sidebarred paragraphs from AG 36.
Okay. Should we do just so we're absolutely clear about your submission? Let's do that. Do you want to sit down, Mr. Chapman,
Yes,
while we do? 36.
My lord, when you've finished with
Yes, well,
that,
yeah, I've just got the last bit.
could I ask you to turn to 43 to 51 of the judgment?
Okay, well, we're going to, I'm just going to name 44, AG 44. So paragraphs in the judgment
43 to 51.
49 to 53.
43 to 51.
Thank you. Yes, as indeed sidebarred. Thank you.
So, save for the reference in the AG's opinion to, or the reference is in the AG's opinion to the Work Equipment Directive, this is principally focused on the Framework Directive. It's worth us looking at the Framework Directive to see how that differs in the way that it's cast. That's starting at page 4 of the Authorities Bundle.
What do we extract from MG in your submission?
That the Framework Directive does not inhere the availability of civil law penalties for breach, and in the opinion of the Advocate General, nor does the Work Equipment Directive.
Which paragraphs do you get that from? Because the issue here was the absence of a procedural remedy in the directive, and the question for the court was, what does that mean?
Yes.
There's no penalties, and the court simply said, well, then you've got to ensure that there's an adequate, effective, proportionate mechanism of domestic law, and they took into account the Charter, the right to an effective remedy, and so on. I mean, you both would accept there is a remedy in national law. You disagree as to the extent of it, and
AG 46, I suggest, is important here. Starting at AG 45, when the member states set out the detailed procedural rules for legal actions intended to ensure the protection of rights, they must ensure compliance with the right to an effective remedy to a fair trial, enshrined, etc., etc. Constitutes the reaffirmation of the principle of effective judicial protection. Then AG 46. Consequently, when choosing the penalties, member states are required to comply with the principle of effectiveness, which requires effective and dissuasive penalties to be established, without, however, in principle, requiring that those penalties be of a particular nature. Those penalties can thus be criminal and or civil. If penalties were not applied to an employer which fails to comply with the national provisions transposing the Framework Directive, in this case, the Work Equipment Directive, the effectiveness and the effective protection of rights guaranteed by the directive would be called into question. So that, in my submission, is very clear authority for the principle that a civil law remedy in relation to a breach of rights in relation to the health and safety of workers in the workplace is not necessary. That it's left to national procedural autonomy, left to member states pursuant to the principle of national procedural authority, subject to equivalence and effectiveness.
This is about article. This is in relation to Article 5. I think it's a. I mean, it's a broad statement, which is probably unexceptionable at a broad level. But there's an emphasis, even in paragraph 46, that the remedies must be effective and must give effective protection of the rights. And then they say if the penalties were not applied, that would call into question that, but they haven't been applied here. I mean, that begs the question as to the merits, of course, but I'm just wondering how far one can stretch these words.
Well, my Lord, I'll
Paragraph 53 of the judgment really,
yes.
just talks about the need for an effective remedy, which one takes one back to what is the scope of the provision. I know there's a degree of circularity about all of this, but anyway.
50, I mean, it may be that there is a degree of circularity. 51 of the judgment, 49 in the first place, in which the court accepts the observations of the observations of paragraph 39 of the AG's opinion. Forgive me.
I've got another problem. I don't know if you would have to say it now or just listen quietly to it as you prefer.
I'm very happy to take
you want to share my pain. I see where you're coming from with this. What it's really saying is, bearing in mind the Framework Directive, that if it's high-level principle protection achieved by obligations on employers, you can't leap to that and assume that whatever benefits, using neutral word, employers will get are meant to be enforceable by them by way of legal action. So that's 4 and 5, and you've got the end provision which appears in most directives, saying member states must adopt the laws necessary to implement it. And it's generally accepted that that gives them a huge discretion in terms of the result to be achieved and whether they go for civil penalties or criminal penalties or both. Fully accept all of that, and that's what it's saying. I fully accept that for parts of the Workers' Equipment Directive. 4 says it expressly. 5 seems to be implicit in the nature of inspections. I think the problem that this court is grappling with is when you're dealing with equipment for workers, 1, the purpose is to protect workers. 2, the wording could be turned around. Workers have the right to be provided with equipment unless that's not possible. And 3, there's nothing to suggest that there's a sort of discretion for member states for that provision to be civil or criminal. That's, I think, the problem that we've got, isn't it? And I don't know what I think at the moment. I just think that that's the pain that I wish to share with you, Mr. Chapman.
Yes, thank you.
I mean, you see what I'm saying, obviously.
I understand my Lord's point. In the end, of course, it's going to be for the court to construe the directive in the light of in the light of the relevant authorities, including MG.
Did you want to show us the framework directive?
I
For some purpose,
Yes.
you alluded to it a minute ago,
yes.
and I don't want you to lose sight of that. If you think there's a relevant contrasting or something that sheds light on our problem by looking at that framework directive.
My Lord, there is. So Framework Directive starts at page 4 of the authorities. The recitals start at page 5 and are cast in broadly similar terms to the recitals in the Work Equipment Directive. In other words, in the usual way, talking about objectives and reasoning. Article 1, it's worth briefly referring to under Section 1 General Provisions, Article 1 Object. The object of this directive is to introduce measures to encourage improvements in the safety and health of workers at work. Article 4.
Well, Article
Yes.
1, 2, to that
Yes.
end, it contains general principles.
Yes.
And you contrast that with Article 1 of the Working Equipment Directive, which is very different, to lay down minimum health and safety requirements. This
Yes.
is general and the other is specific.
Yes, but I'll turn in due course to the more specific.
The Framework Directive, we've got the
yeah.
purpose in Article 1, general principles to encourage improvements in safety.
Article 4, member states shall take the necessary steps to ensure that employers, workers and workers' representatives are subject to the legal provisions necessary for the implementation of this directive to member states to ensure adequate control and supervision. Then onto the same heading, as in the framework, as in the Work Equipment Directive, Section 2, Employers' Obligations, Article 5, General Provision. The employer shall have a duty to ensure the safety and health of workers in every aspect related to the work. And then Article 6, implementing Article 6.1, general obligations on employers. Within the context of his responsibilities, the employer shall take the measures necessary for the safety and health protection of workers, including prevention of occupational risks and provision of information and training, as well as provision of necessary organisation and means, shall be alert to the need to adjust these measures, etc. And then 2, Article 6.2, the employer shall implement the measures referred to in the first subparagraph of paragraph 1 on the basis of the following general principles of prevention, avoiding risks, etc., etc., etc.
Just before, can you
Yes.
help us with 5.3 and 4? The workers' obligations in the field of safety and health at work shall not affect the principle of the responsibility of the employer. What is the responsibility of the employer? Is that a term of art or just a general principle or something else?
I confess I don't know the answer to that. I had read it in terms of general principles that an employer is required to has some form of duty of care over employees.
Is it just simply a reference back to Article 5.1?
I'm not.
The fact that the worker has obligations in the field of worker safety doesn't affect the basic principle that the employer, merging them together, has a duty.
It may be, and it may simply be. It may be that it's tend to suggest that it is stating that the employer's responsibilities generally, including under Article 5, but under the Framework Directive generally, aren't affected by whatever the worker might be required to do.
It's very different in nature. It doesn't provide the answer, but it's 6.2 says the employer shall implement the measures referred to in the first subparagraph of paragraph 1, i.e. measures necessary for safety and health, on the basis of the following general principles of prevention, one of which is in little d the choice of work equipment. So at this stage, it's all clearly tied to the employer and choices of equipment and so on as being a general principle. It would be difficult to spell out of that anything specifically that an employee is intended to be able to insist upon, if you follow me. So that explains partly the reasoning, I think, in this case. But at this stage, it's very high-level principles. And the question is whether Article 3 of the next directive goes one step further.
Well, it is cast in general principles, but it's also cast in absolutes in the same way as the framework, in the same way as the Work Equipment Directive. So a duty to ensure health and safety.
Yes.
A duty to that's in Article 5.1. Duty to take measures necessary for the safety and health protection of workers. That's Article 6.1.
Yes.
I readily accept the point that none of these could be said to place specific obligations on any employer.
Do you think it can be said, look, comparing the two directives, that the obligations on an employer under the Work Equipment Directive are more specific and onerous than under the Framework Directive? And you may not like those adjectives, and there are probably better ones. Shall I show you why I say that? I suggest that to you. Well, you've taken us to Article 5.1 of the Framework Directive, which says the employer shall have a duty to ensure the safety and health of workers in every aspect related to work. Okay? Then if you go back to Recital 6 on page 18 in the Equipment Directive, it explains what this directive is about in these terms, and Mr. Carter honed in on this particular recital. Compliance with the minimum standards requirements designed to guarantee a better standard of safety and health and the use of work equipment is essential, my emphasis, in order to ensure the safety and health of workers. So in order to comply with the general obligation under Article 5.1 of the Framework Directive, compliance with the minimum standard requirements in the use of work equipment is essential. So that the language is more, what's the word?
Well, specific. It identifies the minimum requirement.
It does, and the same. It could be said that the same linguistic approach is adopted in Article 3 itself. When we get to that,
well, Article 1 and 3 to lay down minimum.
Yes,
you know the bottom line.
Yeah.
You can't go below it unless it's not possible.
My lord, the precise adjectives one adopts, one may argue over, but the Framework Directive is specifically designed to provide the underlying framework, which is essentially a springboard for other further directives, such as the Work Equipment Directive. And so, yes, it's not surprising that more particular obligations, and I don't suggest for a minute that there aren't more particular obligations exist in the later directives, such as the Work Equipment Directive. But that I suggest doesn't follow from that the particular provisions upon which the appellant relies inhere a civil law remedy, or that they are required to be transposed in a way that that allows for civil law remedy for breach.
Would you accept that everything in Chapter 2 would fall under the heading of minimum obligation? I'm talking about the Equipment Directive, in particular Article 3. So we're concerned here with so-called minimum requirements.
Yes.
And Chapter 2 really sets out those minimum requirements. Would that be fair?
Yes. And the same is also true for the Framework Directive and any similar directive which will set out minimum requirements.
Does the Framework Directive refer to minimum requirements? I haven't seen any.
It's I haven't checked that, my lord, but it's in the nature of directive that it contains minimum requirements beyond which member states may, in their discretion, go beyond.
It's quite helpful. I don't know. Are you going to look at Section 4 as well, or of the Framework Directive?
Article 4.
Section 4, page 14. Because this tells you how it's going to work. 16 is you can have individual directives like we've got, and 16.3 says got this general directive, and that applies without prejudice to the more stringent and or specific provisions contained in the individual directives. 17A contemplates member states submitting a report as to what they've done to implement the framework directive, and 18 is final provisions member states shall bring into force laws, regulations, and so on. All of that smacks of this directive, framework directive, being high level. Member states will have to comply with it, report on it, and adopt measures, and you can understand the MG. It's just that the flavour of Article 3 of the other directive is a little more specific, and there's nothing like the final to adopt necessary measures. It's to report the measures they've taken.
Yes, my lord, you have my submissions on 3
Yeah.
of the work equipment directive. It is natural that it should be more specific than the framework directive and what's required by that. It
Do you
doesn't follow
accept- do you
from
accept-
that.
Do you accept it's more stringent, the provisions that we're looking at, that as anticipated in Article 16.3 of the Framework Directive, that this is Article 3 in particular is a more stringent provision?
I don't accept that it's more stringent. I accept that it's particularised.
More specific.
It's more. It's,
Yeah, what, to help you, 16.3 says stringent and or specific. You say specific rather than stringent.
Well, yes.
It's hard to
It
see
may
that
not-
it could be any more stringent than an absolute duty, isn't it? I mean, it's fairly top end.
Yeah. Yes. Subject.
Subject to 3.2.
Subject 3.2.
Yes. Can I ask you this? Maybe this is an unfair question. I noticed that Article 1 of the Working Equipment Directive says this is the second individual directive. How many issued under 16.1 of the framework directive? How many directives do you know? How many there are?
I don't know.
There's obviously two, or there at least have been
Yes.
two.
For some reason, and I've not looked at this for some time, 4 rings a bell, but there might be more. We can try to find out the answer.
Yes.
Whatever.
Yeah.
Oh, forgive me.
No, it's just one without opening up the whole thing to greater, more expansive analysis. It might be said that there needs to be some sort of coherence between the interpretation of these individual directives, or maybe we need to look to see if there should be. Anyway, that's just a diversion. Where do you go now, Mr. Chapman?
Could I just conclude my submissions on this point about framework directive by reference to MG? It is my submission that it is clear from the Advocate General's opinion, as adopted in the judgment in those paragraphs that I've turned you to, that the choice of the mechanism for enforcement remains at the discretion of the member state, subject to the usual principles.
Right. Well, now 39 in the AG's opinion answers the question I put a moment ago, doesn't it? Because it lists
yes.
3. Maybe there's the 4th. 3.
It says including. It says including those
So
3.
it's at least 3.
It's at least 3. It must be at least 3. For some reason, I had 4 in my mind, and that may or may not be
that's-
right. My lord, we'll endeavour to get a categorical answer to that question.
Can we just, having read, it was helpful to look at the framework directive, have that discussion. Can I, for my part, just read 39 again, see where that leads us? Yeah, thank you.
Is that any more than a statement of fact that these directives do not contain specific provisions concerning penalties? I think it's a descriptive paragraph.
39 is, and is to be read with the paragraphs immediately before and following up to, in particular, AG 46.
Yeah.
Should we look at footnote 13, which is the footnote at the end of AG 39?
Yes. Well, indeed. For I'd suggest it's I mean it's plainly supportive of the general proposition that if the unsurprising general proposition, if it were wished to be prescriptive as to the availability of civil law penalties for breach, it's very easy for the drafters to say that.
I think it's a slightly different thing. It's two things, really. The first is, what's the nature of the provision? Is it conferring quite benefits at the moment on identifiable individuals, or is it setting out general principles? If it's general principles, it's much easier to say choice of civil or criminal or whatever for the member state. If it's a provision which confers benefits on identifiable groups of individuals, then the question follows, how is that to be made effective? And if it's an individual who's entitled, if this is what we find, to safe work equipment, it means he can go to court and he can say, I haven't got safe equipment. It could come up in a number of ways. He could be bringing a claim for unfair dismissal because he was sacked for refusing to go into an area without ear protection. It could be, I want an injunction, I want to be provided with this. Or it could be, he made me do it, I didn't have a choice, and I've lost an arm and I want compensation. Or here, I've lost my hearing. So if it crosses into the provision of benefits for an identifiable individual, which they are meant to be able to enforce in court, isn't that enough? And what the particular remedy is in the civil court, it probably will be damages, because that's what the remedy is in England and Wales.
My lord, we come back then to the question of what does
Article 3 do?
Well, I was going to say what is the precise content of the right that's asserted.
It does boil down to what we all think about Article 3, doesn't it?
Yes, it does. It does.
Was that meant to enable an individual to go to court and say, I haven't got the requisite equipment? Or was it simply a provision that requires the state to decide whether it's going to criminalise an employer or provide an employee with a civil right to make sure that he's got it? That's the basic question, isn't it?
And it really it is the underlying principle to the objective of this work equipment directive. Is it intended to drive improved standards of health and safety in the workplace, amongst other things by requiring employers to provide employees suitable equipment wherever possible? Or is it a provision which specifically and unconditionally mandates as its objective compensation for injuries caused in breach?
Can I put my lord's question to in another way? Could assume that an employee has his or her employment terminated for use of equipment which causes injury or damage to goods or property in some way to another person, and the defence or that the claim in the employment tribunal is that I wasn't given safe equipment. Would you say that they were not entitled to rely upon the directive to say that in fact my employer was in breach because they had a duty to give me safe employment? Forget damages. Relying on
It
direct
might-
effect as a shield here, perhaps.
yes, it might. That might well be possible, but it doesn't. It doesn't mean, I suggest, that this creates or inheres a right to damages. What I suggest the directive is about is driving standards. And
That's the
it's-
same question. Just right. Is it generally a standards raising thing, and it's for member states to decide how to raise standards, or is it saying to individual employees, "You'll be safe. You've got this right. If he doesn't do it, you go off and tell an appropriate court or tribunal. You refuse to take the orders if they're not coming with the safety equipment." That's the key. Whichever way you put it, it's a different way of asking the same
Yes.
question.
I mean, it really does come down to my lord's
Article
job.
3.
Yeah, it comes down to Article 3 and what that means and what its objective is. I suggest that it's about driving standards. If it were wished to create civil law liability, it could easily have said that. It doesn't say that. We've got the authorities, which MG in particular, which says the precise mechanism is whether civil or criminal liability is up in the air, a matter for autonomy. All of that, in my submission, tends to the conclusion that this is about improving conditions in the workplace as a general public policy measure.
If I lose my arm and I can't claim damages, that doesn't create an incentive on you to improve environmental safety.
If on the other hand, and this is all prescriptive, this is about employers being incentivized to make appropriate choices for the safety of their workers, and one way of incentivizing that is through the coherent and well-developed mechanism in my submission about criminal and regulatory consequences. They can go, substantial fines and worse. And there remains, well, I can deal with it now, the equivalence point, there remains the availability of tortious negligence claim,
True.
where something has gone badly wrong. Now that I don't propose to get into a detailed discussion of the meaning of Article 3, 1 and 2 for the purposes of and a comparison to negligence. We recognise that there is some difference, but it'll often be the case, my lords might think, that where an employer could have provided suitable work equipment and elected not to, then the duty of care will in many cases be breached.
I know you don't want to get into Article 3, but I've just had a quick look at the other directives, which of course, as we can see from paragraph of the AG's 39, they are older. They're actually EEC directives,
Yeah.
as you can see. And none of, so far as I could see, and I know you're not going to respond to this, but I'm just saying it. So far as I can see, they don't, none of them, neither of those other two contains a provision in the same terms as Article 3 of the Equipment Directive. They are both of them. One is about workplace, and one is about personal protection equipment. And they are all, they make specific provision as to what are specific situations or circumstances. So, for example, you may be well off the point here. But so, for example, with the workplace, there's provisions about what emergency routes and exits must remain clear and lead as directly as possible to the open air. That sort of explicit provision. none of them, so far as I can see, contains an obligation in the stark terms of Article 3 of the workplace of the Work Equipment Directive.
Well, my lord, that might be right, but in my submission, that is not sufficient to convert the obligation that's cast in Article 3, 1, caveated in Article 3, 2, into an obligation which inheres a right to sue in civil damages, or which creates an obligation on member states to make such a damages claim available, or such a remedy available.
Thank you. Well, we've probably covered that point now. Where would you like to take us next?
Can I? That was intended to be a point by way of preamble. I hope that means that I can take my observations on the specific grounds.
Yes.
Quite
Well, as you could tell, it's we felt from the word interpretation at the heart of this. I don't think either of you really disagree with that. So I think it does mean interpretation.
Yeah.
It'll have to mean it anyway, even if it's not what you want. I think that's right. Yeah.
I mean, my lord, I am in your lordship's hands as to whether you wish me to go at all to the what was being said in Three Rivers number 3, the distinction between direct effect Van Hend and Becker.
Well, I think really we must leave that to you.
Okay.
You must respond
Yes.
as you wish to,
Very well.
to Mr. Carter's submissions on Becker and Dylan Crawford.
Okay. Well,
Is there much disagreement between you as to the? I mean, all of that is interesting context, but it all says you've got to look at the content of the measure, and then things flow.
yes.
Whereas we're really focusing on what the content. I mean, if you're right, in a sense, there's a full stop drawn, and everything else is just interesting,
Yes.
not really very relevant, and perhaps vice versa.
I think there is. It's academically interesting. Probably nothing much turns on it, but I will take my Lord Justice Baker's invitation to sort of canter through this.
Well, I think you should respond to it.
Yes.
I mean, obviously, what you need to do is on the scale of Mr. Carter. Mr. Carter was helping us through the thicket
Yes.
of the authority in Three Rivers, whereas you can go straight to a key point. I expect.
I'll run through. I think probably these submissions bear on ground 3 and ground 2.
Right.
I'll start with the relevant principles in relation to direct effect and state liability, starting with direct effect. And I do suggest that there is a distinction between the Frankovich line and the Van Hend Becker line.
Yeah.
Starting with direct effect, the starting point, of course, is what is now Article 288 TFEU.
Mm-hmm.
That directives are binding as to the result to be achieved upon each member state to which it's addressed, but shall leave to the national authorities the choice of form and methods.
Yeah.
For your lordship's note, that is cited at Becker, paragraph 17, page 863 of the authorities bundle. The general principle of originating with Van Hent is that direct effect requires the European measure to be sufficiently clear, precise and unconditional. That's repeated in Becker. The position I submit is helpfully encapsulated in Becker itself. For my Lord's note, paragraphs 17 to 25, starting at 863, authorities 863. The court there restated court there restated the sufficiently clear, precise and unconditional criterion. It makes clear that the principle extends, a direct effect principle extends to faulty implementation. It makes the obvious point that this is about verticality. And I would emphasise in particular paragraph 25, Mr. Carter, I think, is taking you to it. Wherever the provisions of a directive appear as far as the subject matter is concerned to be unconditional and sufficiently precise, those provisions may, in the absence of implementing measures adopted within the prescribed period, etc. Those are well understood and consistently applied principles. Can I briefly address the submission that Mr. Carter has made in relation to Three Rivers and propose what I say was, Lord Hope was saying there? The punchline I suggest is that Lord Hope's approach was entirely orthodox. Starting at page 197E, which is 655 of the authorities bundle. 197E6, page 655. Mr. Carter briefly took you to this. The judgment of Lord Hope, or opinion of Lord Hope, begins at 197E through to 198F by describing the way in which the claimant put the EU law argument. And over the page at 656C, the point being made was that the directive imposed certain well-defined community law obligations.
Mm-hmm.
Then from 198G, same page,
Yes.
G, Lord Hope identifies and discusses the two distinct routes by which a directive can be enforceable against the state and domestic court. So the first route, see over the page at A, or going over the page to A, the first route by which the state, by which the right to claim damages against the state or its emanation, etc., is direct effect. It's the Van Gent Becker line, direct effect. And then at B, at 199B, at the bottom of that paragraph, you see he says the second route is based upon the principle of state liability. And then at the start of the next paragraph, between 199B and 200B, he explains in detail the principle of direct effect and its criteria by reference to Van Gent and Becker. Before turning at 200B to state liability, to the state liability route, by reference to Frankovich, back to Tame and Dylan Coffer. Then from 201H over the page at H, he identifies that the main difference in the Court of Appeal as to the principles to be applied concerned whether a directive remained an immediate source of rights. From 202E, he referred to Lord Justice Old's observation that the key question, effectively, I'm paraphrasing, effectively the key question is whether the directive is given effect to one way or the other. So we're circling back to the point that we've all landed on. And at 203, again over the page, 203A to B, Lord Hope concludes that through whichever prism, direct effect or state liability, the essential issue in that case was about the meaning of the directive and whether it contained a specific right to damages. Then moving forward to his conclusion on that question, and that was because of the way that it was articulated. The community law point was articulated by the appellants in that case. Moving forward to 291B to C, Lord Hope deals with that question. Mr. Carter's taken to this passage, substituting the Frankovich test for better.
Sorry, you say 29.
Forgive me, 219.
219.
Internal.
Yes.
219B to C. This is Mr. Carter took me to this. Looks at the ultimate question, substitutes Frankovich test for the Becker test, and concludes basically that through whichever route one takes, the answer is the same because it turns on the context of the directive.
Yeah.
So we don't accept that this is authority for any general proposition that Frankovich and Van Hen-Becker are aspects of the same thing. But so there as here, it all, in that case on those facts, and in this case on this directive, turns on what the directive means.
Well, isn't it? Can't we proceed on the basis, as he says, I think in 661B, referring back to Dillenhofer, the right to reparation where the results prescribed by the directive entails the grant of rights to individuals. The content of those rights is identified on the basis of the provisions of the directive and a causal link between the breach and the loss. Do you accept that?
Yes, on the Frankovich route. Yes.
Well, that's the question. The other problem is this. Frankovich is all about a failed implementation or inadequate implementation, and you see the state, His Majesty's government. Where we're getting confused, I think, is in direct effect and remedial consequences.
Yes.
Direct effect is a label that describes when things are in a directive, they can be relied upon before a domestic court. You can put it in your claim form. Mr. Carter just refers to the three things, but you've got the strong sense that this court asks, firstly, what is the right? On whom is that right conferred? And if you analyse it and it's conferred on workers and it's sufficiently precise, then it can be enforced in domestic courts. That's the first stage of direct effect. The next question is, what do you do with your newfound directly effective right as a worker to safe equipment? And the problem here is the state hasn't chosen any specific means to enforce it. And the normal fallback is you bring your ordinary civil law claim. It used to be statutory duty in a different sense. The duty to give effect to Section 2 of the European Communities Act was what was said to be the ultimate route. And that's what I think they're getting at here, and what's being confused is, does this confer a right on an individual worker to be able to go to a court to get safe work? Yes. Does it also include a right to damages if he hasn't had safe work and has suffered as a result? Answer, probably yes, because of effectiveness. And the way we used to do it in the United Kingdom and all the factor-taking cases was to say, which is ultimately a breach of Section 2 and the duty to give effect to directly effective rights. So if we decide that a worker was entitled to have a right enforceable in a national court, then he may probably have a right to damages if he doesn't get it and is injured. Isn't that the proper analysis at the end of the day?
Can I say I agree that there is the risk of confusion between the different routes, and one has to be careful as to the analysis which is adopted, which gives rise to a right to damages, if any.
Yeah.
So on the one hand,
Direct effect is not about a right to damages. Direct effect is about whether a
Yes.
right is conferred on an individual which he or she can enforce in the court.
yes,
We haven't got to remedies yet.
yes,
Forget about that. Does this give a right to a worker? Can he or she go to court and say, look, I've got a right, the directive meant me to have a right? That's the first question, is it a direct effect?
there is a, so if there is a right in my submission, it is not an absolute right to, or an enforceable right in the domestic courts to not be injured through the provision of unsuitable equipment.
So there is or is not.
There is not a right.
But that's a question of analysis.
Yes.
And if we disagree with you and we say, no, this is different, it's minimum standards, it was meant, it was intended to give individuals a right to be able to go to court and say, that employer has not given me what Article 3 says I'm entitled to. I'm entitled to it. That's all the direct effect says. He can get through the door of the court. The next question is a purely domestic question.
Yes.
What remedy do I, the county court judge, give? And the answer, with factor team and all the others, is when there's nothing else left, you treat it as a tort, you treat it as a breach of statutory duty, because the only route ultimately that you've got was Section 2 of the European Communities Act. That's what they used to say about factor team and all the other cases. So he's entitled to be protected, and it's for us to choose how, and if we haven't done anything else, we give him damages.
Yes.
And
Um,
unless you're saying there's a positive choice on the part of the United Kingdom only to say, no, you can't have damages, you can only have civil prosecutions against the employer. But that doesn't seem to be consistent then with it being a right for the employee to go to court and complain, I haven't got my earmuffs.
If there is a right, my lord, I suggest that this comes back to the question of what specifically the content of the right is. And really, that is.
I think that's the one
That's-
question in the case.
that's
What
the
does
one
Article
question.
3 mean?
It is.
Yeah.
Right. So you're being drawn back like
We
a
have.
moth to the flame of Article 3. I'm very conscious of time, and we must
Yes.
let you, I think, now develop. I think you said all you want to say on Three Rivers, haven't you?
I said all I want to say on Three Rivers. I might just, may I just check my notes to see if there's anything else that I
No,
need
please.
to see on grounds 2 and 3,
Yes,
and if there isn't, then I'll move on to ground 1. Would you give me a moment?
of course, because we have interrupted you.
I will.
Have you said anything more
I
to
do
say?
need to talk about equivalence.
Oh yes, I've forgotten about equivalence. Yeah.
Yes. How much do we need to talk about it there? Really?
Probably not very much. But I need to cover it off at least.
Yes, you do.
So as my lords know, the general principle is that the rules must not be less favourable than those governing civil
Yes.
domestic actions, and then the question is, what is the civil and domestic action? And there, Preston and Wolverhampton. I'm not going to take you to.
Yes.
You've got the points. Starting point is to ask whether there's a similar domestic action.
Yeah.
To take as the comparator. And as Lord Clyde said, we refer to this in it's sidebar, we refer to it in our skeleton. If there's no comparator, if there's no domestic comparator, then that's the end of the matter. the point was developed by Lady Justice Arden, giving the lead judgment of the Court of Appeal in Total. That's, again, I don't ask you to turn it up, but for your notes, starting at 835 of the bundle at paragraph 7, she refers to the two-stage process, identifying the similar domestic action and examining the justification for any difference if a domestic comparator can be found, which is a domestic action covered by different procedural rules. She observes paragraph 7 that according to the jurisprudence of the CJU, it's for the national courts to determine whether the domestic action is similar or the putative comparator is similar, with similarity to be assessed with reference to the domestic action's purpose, cause of action, and essential characteristics, a point that my lords have.
Yeah.
But she does observe, paragraph 51, that that's not always a straightforward question. The National Court, she says, has simply to do the best it can. The degree of abstraction necessary to find whether similarity exists must be a matter of judgment for the National Court. And then paragraph 47, she makes the point that no less favourable does not mean the most favourable or more favourable as compared to comparator causes of action.
Yes.
So the first question is, does any relevant domestic comparator exist? I suggest that one has here, again, to identify what, if any, right is created by the directive and what the content of that right is in order to identify whether there is a relevant domestic comparator. I suggested earlier that the right, matter for my lords, but the right might be a right to expect the state to take reasonably effective action to reduce the likelihood of injury or death at work, including by reference to Article 3, to take effective measures to ensure that employers provide suitable work where possible. Perhaps the most closely equivalent domestic regime is that relating to the dangerous use of vehicles, which is in its own way designed to reduce the risks posed to road users, the instance of injury or death on the roads. It may be a stretch to suggest that that's a suitable comparator, but if that's not it, it's not clear what might be.
It's one of the problems here that when Section 47 was removed, it was removed from the entirety of the health and safety regime.
Yes.
And that's really, you're looking to try and find a comparative which is itself mainly protection of workers in the workplace.
Yes.
So
and
it's quite difficult to really identify what a comparator is.
It is. And that really is where, or one of the ways in which any argument based on non-equivalence or breach of the equivalence principle fails.
And then it may just boil back down to, is such remedy as exists effective?
Quite. And that really is the point, that no argument is taken on effectiveness. And I would suggest, rightly so, in that there's no basis to think that the calibrated system for enforcing.
I think it may be slightly optimistic to say that no point is taken. It may not, in the way in which the argument is framed, it said there is a right, it is directly effective, we've
Yes.
got nothing else.
Yes.
Or we haven't got a
Speci-
right in tort.
Specifically in relation to effectiveness, it's not suggested, and this of course depends on whether one interprets Article 3 and the directive generally as being designed to promote improvements in health and safety. I think that's probably all I need to say on
Right.
equivalence.
So that takes us finally to ground one.
To ground one, and I'll be quick on
Yes.
ground one. We suggest that it's now clear on the domestic and CJU authorities that whether a body is an emanation of the state is nuanced and fact specific. We take that from what Lord Justice Flo said in Lewis and Tyndall.
We haven't looked at that. Do you want us to look at that?
Yes, please. It's starting at 392. I think I'm asking you to turn to paragraph 31, which I think is probably 392. Yeah. Could I ask you, please, just to read paragraphs 31 to 35?
Do you want us to read the quotation from the CJEU
Yes, please.
in 355, in paragraph 35?
Yes, please.
Thank you.
I can't decide. Is it entirely, it's either or you must have a bit of one and two, but it doesn't have to be all of one and two.
So
Probably my problem.
what
We
Lord
got-
Justice Flo records is that the CJU adopted the opinion of Advocate General Sharpston, where she said at point 53 that it's neither conjunctive nor disjunctive, but rather a description of the relevant factors, a non-exhaustive list of the relevant factors to be taken into account, or which may be taken into account.
It's not one or two, it's 1 through 6, and you can have some of those, and that'll be enough.
Yes, it doesn't say that'll be enough, but it's going to be a weighing of the evidence to decide whether the factors pointing to being a state organ and away from being a state organ are assessed.
We don't have the CJU case 2 in here.
You've just relied on the quotation from Lord Justice Flo.
We've just relied on the quotation. Yes. If it would assist, of course, we
I
can.
can get you, don't worry. So what do
We
do
we
then?
suggest that the questions simply aren't straightforward, and the courts below had inadequate evidence upon which to assess this question. So, for example, the question is: is the student loans company governed by public law as a legal person that's part of the state in a broad sense? Factors that feed into that question might include the extent of its public funding, the precise scope of its functions, the fact that the company is passed by Parliament to undertake certain functions, albeit those are not dispositive as to amenability. Is it subject to the authority and control of a public body? In this case, relevant evidence may include the precise ownership and governance structures, the way that they operate in practice.
These are all things that might be relevant. We don't have any evidence of. Is that right?
That's the point. Yes.
It would all have been in your hands.
Yes.
It would have been quite easy to produce an agreed statement of facts, I would have thought. Most of it would incapable of being disputed.
That is fair insofar as it goes. My lords will have seen some of the procedural history from the papers in the core and supplementary bundle. So there was a statement of evidence dealing with at least some of these matters. Of course, one of the problems was that the parties were unaware of the judgments and so didn't refer the county court to Lewis and Tyndale or the relevant authorities. But true it is that this evidence would have been available to be produced. A witness statement was produced.
I think probably if we'd been case managing this, we'd have said at an early point that he's produced an agreed statement of facts, just setting out the legislative and statutory constitutional basis.
Yes.
I'm just looking at page 371 because we haven't got the CJEU in Foster. And I'm looking at paragraph 20 to look at the sorts of things that covered 18 and 20. Well, we know this is a public service under the control of the state. One notice legal form made responsible pursuant to a measure adopted by the state. Because that was found as a fact and there's no respondent's notice. So far as the first fact, which is a fact to know, not an either or, tick. Then the next question is, for that purpose, special powers beyond those which result from the normal rules applicable in relation to an individual. We've been shown things to do with the HMRC, and the student loan company and the individual can use the mechanism of HMRC, pays-you-earn taxation, as a means of paying the loan.
Yes.
They've got special powers. When I borrow money from Barclays, I can't say, don't worry, Barclays, I'll do it through my PAYE. So they've got special powers, we know that. So given that you put in no evidence and no respondents, why isn't that enough to say, well, on the material before us, it is an emanation of the state? Or do you say all we can say is Air J was wrong and therefore we've got to send it back, even though it's partly your fault for not showing them the right case law and producing the evidence?
We do say that.
That's what you say. It's got to go back.
We
just because it's wrong.
In any event, this case will have to. This is an appeal on a preliminary issue. It's going to have to go back before the county court anyway.
It's got to go back on causation, failure to provide suitable equipment, and you say also whether it's an emanation of the state. It's a bit unfortunate. It's 3 days and we still don't get anywhere near it, do we?
It is, I don't think there's.
If we sent you away to draw up a list of the statutory framework of the SLC, and you produced it and just defined its characteristics and its powers and its responsibilities, all of that is pretty much public domain information. Would we come to any different conclusion to that of the judge?
Well, the judge said it wasn't an emanation of the state. That's the problem.
Yes, Judge Friedland. I was just reading what Judge Friedland.
Friedland said, yeah.
I'm not reading his judgment, but I'm reading what Mrs. Eyre said, quoting extensively. It is amazing. There's quite a lot of analysis of this and arguments, but no evidence.
Yes.
As Paul says, I was almost tempted. I find my hand moving towards the screen to just Google and see what information we could find out about it. I mean, it's a fairly. I'm not doing that, but it's a fairly rudimentary thing to produce evidence about. It's surprising considering there's all this discussion by Judge Freeman. Anyway,
My lord, I'm handicapped slightly here in that I haven't myself gone to the public domain to see what is available on this issue. But there's another point, which is how does the governance as a relevant factor, one of many, how, by way of example, does the governance structure, how is it calibrated, how does it work in practice, to what extent is the student-led company a genuine arm's length body which is free of interference from the state?
Justice Foster gave you a very strong encouragement to put in evidence, and you are the Student Loans Corporation, you are an arm's length body. You've taken 3 chunks of court time to say, we don't know, so you must send it back, when you do know.
My lord, all I can do is apologise for the fact that that wasn't done.
was it down to you to do it? I'm just wondering who's.
Well, my client or me?
Not you personally.
Not you personally, obviously.
No. Well, which part? Who was asserting that? The claimant was asserting.
So
it's in paragraph 3 of 2 of the statement of the particulars for claim.
Precisely, it fell upon the claimant to advance and make good the point. It was in the particulars.
They did advance it.
Yes.
Question
Paragraph
is,
3.
you want to deny it,
Yes.
and the information which goes to the denial essentially lies with the SLC.
And not only that, one of your employees made a statement.
Yeah.
They chose to put in evidence. And if you put in evidence it's the truth, the whole truth, and nothing but the truth in the old-fashioned way, you'd have thought a bit more than, no, it's not, would have been called for.
My lord, I don't seek to push back against that. Of course, I hope it's not a cheap point to take, but it would, of course, have been open to have put all of those points to the witness at first instance. It would have been open to advance evidence, but I accept.
One feels this is really a matter of, it's the inferences to be drawn from an uncontroversial statement of statutory background. I'm not certain it's a matter of cross-examination. You know what the statutory context is, the relationship with the HMRC, all governed by rules. It's really an inference of law to be drawn from that material, I think. Not certain, but what the individual employee thinks about it is may not be relevant.
Yes, all I would say,
what they think about it, evidence they produce, from which the court could draw an
The statement below simply said, I think he put stuff that you could get off the website, and he said, I, the employer, don't think it is a emanation of the state, and that was your evidence. Well, that's his opinion, which may be very valuable, but is not proper evidence. You chose to give some evidence.
What I would say is that it's unlikely, when one looks at the list of factors, it's unlikely to be sufficient to refer exclusively to what's available in the public domain.
Okay,
So,
right. I'm conscious of the time.
yes.
So just to round this up, how do you invite us to deal with this point?
I would submit that it is. I mean, of course, if you're with me on ground 1 and ground 2, we don't get to it.
Yes, if we're against you on ground 2 and 3 and all 3,
Ground 2
then ground 1 comes into play,
and ground 1 comes into play.
and you say at that point we should what? Allow the appeal and remit?
At that point, it's clear that Mr. Justice Eyre entered into error of law.
Yeah.
In relation to this, he was misdirected, and so it is open to you to allow the appeal on the basis of that misdirection. Remit to the county court for them then to consider the question of emanation of state.
Yes.
So this would
Just
be
wondering whether that needs
A waste of time.
No, because they've won below. They're not trying to uphold it on additional grounds. It's got to be set aside and sent back.
So you're
They
I just
can,
yes, I
what
was,
you're saying.
you heard me mutter in response to this. You are not defending the basis upon you're yeah.
You're resisting the appeal, I think.
But yes. But if we allow the appeal, okay, I
I
think
thought if you were to allow the appeal, you'd obviously do so on the basis of a judgment which explains the reasons, explains the legal
Yeah.
principles upon which these questions should be determined by lower courts.
yes, and okay, all right. I think we've got your point on that. Thank you very much. Anything?
So thank you very much.
Thank you, Mr. Chapman, for tolerating our interest in the case. Mr. Carter, what do you
Right, so
want to
just
say?
have a few minutes, I'll be quick. but
No,
just
that's
a
fine.
few-
We've got 20, we got to 1:15, so I'm not sure you need to go that long. Whatever you want to say, please do.
I'm not contending against the ultimate question being looking at Article 3 of the Wetherell Directive, but just to reply particularly on the MG case,
Yeah,
to make clear my position on what the framework should be.
Yeah.
MG, just to be clear, because a lot of reference is made to it, is another case, along with all the respondents' other cases, on equivalence and effectiveness. It's not on direct effect. And it doesn't refer at all to the Becker conditions or the Dillon-Coffer conditions. Those cases are listed in the list of cases cited. And the other side of the coin, as I've said before, is that Three Rivers doesn't analyse or rely on equivalence or effectiveness. The reason both sides of the coin are there is because they are completely distinct. And so, as I said before, I'm not contending that you don't look. Obviously, you look at Article 3 of the directive, but just to, I hope, sweep away the MG and the other cases that might cloud your the prism through which you view that directive. And the respondent hasn't addressed you at all on the Becker conditions or the Dillon-Coffer conditions. Reading between the lines, I think it would probably be said, I think on the second condition about the instance of the rights is clear, or first about the rights to individuals, we all understand the point about the court's concern to say, is it a right as such, or does the right include the need for a remedy? But the respondent hasn't addressed you on the relevant conditions for direct effect for ground 3. And given that all of the respondent's case law is on equivalence and effectiveness, you've not got any cases telling you how to interpret the directive. And so my position is you have to look at it purposively. You look at the fact the objective is trying to achieve an outcome. And so really my invitation is to be fairly broad and generous in your interpretation of Article 3, which is ultimately the crucial part. And as I say, not to be drawn into error by reference to MG or any of the other cases. I think really, my lords, in truth, that's the only point of reply I wanted to raise, so thank you for my submission.
well, thank you very much, both of you. It is a very interesting legal point, hence our interest, and engaging in a debate which I'm very grateful to you for responding in a way that you both did. I think you said that. Grateful to those who sit behind you for the work they've no doubt contributed. We're going to reserve our judgments, obviously. In due course, we will send out draft copies in the usual way for you to correct any typographical or minor errors. Obviously, it's not an opportunity to re-argue the case. Please bear in mind the rubric at the top, warning you of the consequences of any unauthorised disclosure of the draft. In due course, we will hand down, after receiving your corrections, we will hand down the judgment. Virtually no need for you to attend. Insofar as there are any ancillary matters arising from my judgment, we'd be grateful if you would agree in order. Insofar as there's any disagreement between you as to the terms of that order, please put forward brief submissions in writing, and we'll resolve those matters on paper. Thank you very much.